Hi, Robert Wareham at the Law Center, continuing our series on extreme risk protection orders that were created under House Bill 19-1177, the law signed into the bill signed into law by Governor Polis just recently. It will take effect on January 1st, 2020. The delay in it taking effect was to allow the Office of Peace Officer Standards and Trainings under the Attorney General's office to put in place policies and procedures for law enforcement in dealing with these, and also to allow the State Court Administrator's office time to create standardized forms and petitions and things like that to be used. So in our earlier segments, we talked about how the process works, what evidence the court's to consider, what your options are at the 14-day hearing, or rather what the court's options are. Your options are to present evidence, obviously. And so now what happens? Let's say an extreme risk protection order is entered for 364 days. Statute does provide that one time during that 364 days, you can ask the court to terminate the order. And you know, it's kind of implied that the court will look to see if there was something that changed from the time the original extreme risk protection order was entered. And the court does have the ability, if it holds a hearing on a requested termination, it can continue that, so that if it's looking for progress, the court could say, okay, it does appear you're making progress. I'd like another couple of months to go by before I rule on your motion whether to terminate the extreme risk protection order early, meaning prior to the expiration of 364 days. Now, by its very terms, the order will expire after 364 days, and lacking a renewal of the order, then the respondent would be permitted to get back their firearms and presumably their concealed handgun permit. But there are some procedures in place here too where that makes it, shall we say, less likely that that will happen automatically. What the bill provides is that the court shall notify the petitioner, meaning whoever brought the petition in the first place for the extreme risk protection order is going to be notified by the court 63 calendar days before the date of the expiration. So the permanent order is good for 364 days, so at least at about day 301, a notice is supposed to go out to the petitioner that, look, this order that you requested is going to expire in 63 days. Do you wish to have the order renewed? And basically the same standing, a petitioner, a family or household member or law enforcement officer may request renewal of an extreme risk protection order at any time within that 63-day period. And upon receipt of the motion to renew, the court again shall order that a hearing be held not later than 14 days after filing the motion to renew. So it essentially kind of starts the whole initial process over again. The court is allowed to conduct a hearing by telephone again, and the respondent, the person who is restrained by the extreme risk protection order, must be personally served in the same manner as they were with the original order. And once again, the court must consider whether all relevant evidence and all the factors that it did in the original hearing that resulted in the extreme risk protection order. And then it says, and I'll read straight from the legislation itself, if the court finds by clear and convincing evidence that based on the evidence presented pursuant to 1314.5105 sub 3, the respondent continues to pose a significant risk of causing personal injury to self or others by having in his or her custody or control a firearm, or by purchasing or possessing or receiving a firearm, the court shall renew the order for a period of time the court deems appropriate, not to exceed 1 year. So again, we're back in to the situation where this could be a further 364-day extreme risk protection order that would prevent the respondent from possessing, owning, purchasing firearms for the next 364 days. In the order, the court shall set a return date to review the order no later than 35 days prior to the expiration of the order. However, if after notice the motion for renewal is uncontested and the petitioner seeks no modification of the order may be renewed on the basis of petitioner's motion or affidavit signed under oath. So in other words, if the respondent doesn't come back and try to contest the renewal, the court doesn't even have to hold a hearing. The extreme risk protection order is just automatically extended. If an extreme risk protection order is terminated or not renewed for any reason, the law enforcement agency storing the respondent's firearms shall provide notice to the respondent regarding the process for return of the firearms. So that's essentially the process once an extreme risk protection order is entered and it has come up to near expiration. Without a motion for renewal filed by the petitioner, the extreme risk protection order will expire on its own. If a motion is filed, the court needs to hold a hearing. If the respondent objects to the renewal, if the respondent does not object to the renewal, then the court can go ahead and just renew the extreme risk protection order without a hearing taking place at all.